You know, we all worry about making a little mistake on our taxes. But what happens when that so-called mistake isn't really a mistake at all? Well, today we're tearing down a pretty dense legal document to find that exact line, the one where a simple tax error turns into a serious, honest-to-goodness crime.
Okay, let's just get right to it. When you think about a tax mistake, you're probably picturing a stern letter, maybe a fine. But what's the absolute worst case scenario? And I'm not talking about money here. I'm talking about handcuffs and a jail cell. Yeah, it can get that serious.
So to make sense of this whole thing, we've broken it down into 6 key parts. Think of it as our roadmap. We're going to start with the moment a tax issue crosses over into criminal territory. Then we'll look at 2 very different kinds of offenses, what I call crimes of inaction, and then the more serious crimes of deception. After that, we'll see what happens if you try to obstruct the system, what goes down when a company is the one committing fraud, and finally, how these cases actually get to court.
All right, first things first. Let's tackle the biggest question right off the bat. When exactly does a tax problem become a criminal act? Getting this distinction right is the key to understanding everything else we're going to talk about.
And here is a really crucial, kind of scary legal point pulled right from the Tax Act. Criminal charges are applied without prejudice to other penalties. Now, what does that legal jargon actually mean? It means you can get audited, fined, and ordered to pay back every single penny you owe, and then, on top of all that, you can face separate criminal charges. It's not an either-or situation. It can absolutely be both. So, what kind of behavior can even trigger these criminal charges? Well, this first category might actually surprise you, because it's not about what you do wrong, it's about what you fail to do right. These are the crimes of inaction, basically the legal price you pay for not cooperating. So, what does inaction really mean in the eyes of the law? Well, it covers a pretty wide territory. It could be something like just not handing over information when they ask for it, or, a bit more serious, refusing to let them inspect your books. A huge one for businesses is failing to deduct tax from an employee's salary and pay it to the government. At the end of the day, if a tax authority officially tells you to do something and you just don't, you're wandering into this danger zone. And the penalty for this kind of non-compliance is no joke. If you don't have a really good, reasonable excuse, you could be looking at up to 1 full year in prison, or a fine, or even both. It's a pretty clear signal that the system expects, at a bare minimum, your cooperation. Okay, so just failing to act is one thing, but the law gets a whole lot tougher when we move from that kind of passive failure to active, intentional deception. This is where we cross that big, bright line into outright fraud. This slide right here is so important for understanding the legal mindset. On one side, you've got inaction, just failing to do something. But on the other, you have deception, actively and intentionally doing something to mislead. It's the difference between forgetting to file a form and deliberately hiding income or handing in fake documents. The law sees a massive gulf between these two, and it all boils down to one thing: intent. So the heart of the matter is what the law calls a willful attempt to evade tax. Under Section 312, it's basically any scheme where you hide income, lie about your assets, or cook the books, all with one goal: to avoid paying the tax you owe. And that word willful is everything. It means you knew exactly what you were doing. It wasn't an accident. This table lays out the real heavy hitters in this category: knowingly giving a false statement, filing a return with a completely bogus audit, and of course that big one: willful tax evasion. And just look at the punishments. Notice a pattern? For every single one of these, the maximum penalty is a very serious 5 years in prison. 5 years. That's the max. But here's the kicker. The law also sets a minimum for these crimes. You're looking at 6 months of rigorous imprisonment, which can and often does involve hard labor. The message here couldn't be clearer. Intentional fraud will be punished, and it will be punished severely. All right, so far we've been talking about crimes related to your own taxes. But what happens if you start interfering with the authorities themselves? Well, that brings us to our next category: obstructing the system. This is all about what happens when you decide to get in the way. You can really see how the penalties ramp up depending on how much you interfere. Just getting in an officer's way while they're doing their job, that could land you in prison for up to a year. If you actively help someone else commit a tax crime, that doubles to 2 years. But the most serious of all is trying to stop them from seizing property. If you've been given notice and you try to sell or hide assets to keep them away from a taxman, that's a 5-year crime. So we focused on what happens to individuals. But what happens when the entity breaking the law isn't a person but a whole company or a firm? Who actually takes the fall? This is where the law creates something called dual liability. And it's fascinating. The company itself gets punished, sure, but only with a fine. The real legal firepower is aimed squarely at the people running the show. Every director, every manager who is responsible is held personally liable. And for them, the penalty is severe. A minimum of 6 months of that rigorous hard labor imprisonment, going all the way up to 6 years. So, is there any way out for a director in that situation? Well, yes, but the legal bar is incredibly high. It's not nearly enough to say, hey, I didn't know. You have to actually prove the crime happened despite you exercising what's called due diligence to prevent it. That means you had systems in place, you followed up on red flags, and you actively tried to stop it from happening. That is a very, very tough argument to win in court.
Okay, we've covered the crimes and the punishments, but how does a person actually end up in court for any of this? Our final section looks at the official, step-by-step path to prosecution.
The process is actually very structured, with some pretty clear checks and balances. A prosecution can't just be launched by anyone. First, it needs prior approval, a sanction, from the Commissioner of Taxes. Once that's approved, a deputy commissioner has to make a formal written complaint. And finally, the case doesn't just go to any old court. It's tried by a special judge who's been designated specifically for these kinds of offenses. Now, just when you think you've got it all figured out, the law throws in this massive curveball from Section 325. It gives the commissioner the power to compound an offense. What does that mean? It means they can settle the case, usually for a payment, and just drop the criminal charges. And get this, it can happen before or even after the case has already gone to court, as long as the board approves. It's a powerful off-ramp from the whole criminal justice system. And that brings us to our final and I think most important question. On one hand, the law sets up these incredibly severe punishments. We're talking years of hard labor. But on the other hand, it provides this powerful option to just settle the whole thing. So what's the real goal here? Is the system designed to prioritize compliance, using that punishment as a big stick to get people in line? Or is it about delivering real consequences for the crime itself? It's a fundamental question about what our tax system is really all about. Let us know what you think. Thanks for joining us.